Hello and welcome back to another video by the A-Level Law Teacher. Today we're going to be looking at Statutory Interpretation, which is on paper 2 of the OCR law specification. So it's the beginning section to the tort law paper, and it's one of the sections you need to know. It's one of the biggest sections there's quite a few questions, 8 and 12 markers that can be asked. So it's quite an important topic to go through. It's also an important topic at university that you often look at in the sort of English legal system section. What do you need to know for this topic on the specification? You need to know the 4 rules of interpretation, otherwise known as the literal rule, golden rule, mischief rule, and purposive approach. You also need to know some other elements, which includes rules of language, intrinsic and extrinsic aids to interpretation, the impact of EU and Human Rights Act law on statutory interpretation, and you also need to know the evaluation of this topic. So that includes advantages and disadvantages of the different rules of interpretation. So that's the literal rule, golden rule, mischief rule, and purposive approach, and the different approaches to statutory interpretation. So we'll look through those later on. Firstly, we're going to start with the literal rule. With these 4 rules, the literal rule, golden rule, mischief rule, and purposive approach, it's important to look at these topics with 3 themes. I always would think of it as a definition, a comment, and some cases. And as long as you sort of include those 3 things, you should get good marks on these, as long as you can be as accurate as possible. And make sure when you're looking at the cases, you're using more than one. So you're looking at 2 or 3 cases and making sure that you're explaining how the rule was applied in those cases, not just mentioning the cases. So if we start with the literal rule, this is where the court gives the words their plain, ordinary, or literal meaning, even if this produces an absurd result. So even if the result is absolutely ridiculous or stupid, the judges go, well, that's what it says, that's what the word says, that's what Parliament used, that's what we're going to use. And there's a longer definition of this rule by Lord Esher in the case of R.V. Judge of the City of London of Court, 1892, but essentially that top definition is a paraphrased version of that. The comment on this rule is that it really respects parliamentary supremacy and separation of powers, and let me just talk you through those 2 things. Parliamentary supremacy is the idea that Parliament is supreme, hence the name, because they are elected and therefore they are accountable to the electorate, to the people that vote, to this country, because if you don't like what they do, if you don't like the laws that Parliament create, you can vote them out at the next election, and that's the idea and the democratic ideal of that. So this rule really respects parliamentary supremacy because it's judges who are unelected, remember, saying, well, actually, Parliament wrote the law, they're supreme, we're going to follow exactly what they said. And we're not going to question it, even if it produces an absurd result. That's what Parliament said, so that's what we're going to do. We're going to follow it. It also respects the separation of powers, which was come up with by a person called Montesquieu many hundreds of years ago, I believe. And the separation of powers is an idea to basically enshrine democracy, to make sure democracy maintains. And it's the idea that you separate the 3 arms of the state, so of government essentially. So you have the executive, the legislature, and the judiciary. So the judiciary is the judges, of course, and the executive is largely the government, the people that run the country on a day-to-day business, and the legislature is Parliament, so the people that make the laws. Now, separation of powers tells us that the judiciary should be separate, so their job is to apply the law, not to make the law. So in this case, where they are literally just applying the law, whatever the rule says, they're applying it. They're not putting on their own spin on it. They're not trying to change the law. They're just doing exactly what Parliament has said. It clearly respects the separation of powers. So that's your comment. That's your strong approach on this one. In terms of cases for the literal rule, the first case is a case called Cheeseman v. DPP. He was caught by 2 police officers who were stationed in the toilets. He was caught masturbating in the toilets and convicted of a criminal offence, obviously. The law they were trying to convict him of used the term passengers, and the problem in the court was when they looked at the definition of passengers, and this law was written many years ago, and they looked at the dictionary definition of that word at the time, because of course passengers today means passengers in a vehicle, a person that's not driving, etc. But when this law was written, what it actually meant was coming and goers, so passers by, essentially, people that were passing by or coming in to use the toilets, then leaving. Now, in this case, it was successfully argued that the police officers weren't passengers then, because they weren't coming and going. They were stationed there specifically to catch him. So therefore, he was found not guilty and not convicted of it, which is clearly an absurd result, but they were following the plain and ordinary meaning of the word passengers at the time the law was written. The next case, London North Eastern Railway Company v Berryman. A man was killed whilst maintaining the track. He was just oiling them, maintaining the tracks. And the law basically entitled his widow to some compensation, etc., some money for various means, and but only in the case if they were killed whilst relaying or repairing the track, and basically they didn't have a guard on to warn them, and there's a bit of the complicated law to it, but basically it was the idea that he was killed whilst relaying or repairing the track. And in this case it was successfully argued that relaying or repairing didn't include maintaining. Maintaining is a different thing to relaying or repairing, and therefore Mrs. Berryman unfortunately was not entitled to any money, which is again an absurd result clearly, but they were following the plain and ordinary literal meaning of the word. In Whiteley v Chapel, a person voted and then impersonated a dead person to vote again. So they voted twice in an election, essentially. And the law used the phrase impersonating someone entitled to vote. And of course, it was successfully argued in this case that a dead person is not entitled to vote, and therefore the law was technically impossible to break in this instance. So applying the plain, ordinary, literal meaning of the word, that they were not guilty in this case, which again clearly is an absurd result. And finally, in Fisher v Bell, if you've studied contract law, you'll certainly go on to, if you're doing contract law on your specification where you are, you'll look at Fisher v Bell certainly when you look at offer and acceptance. So it's a really famous case. In this case, he was selling a flick knife. It was in the window with a price tag on, and he was charged with offering for sale a flick knife, which was illegal at the time. And it was successfully argued in a court that he wasn't actually offering it for sale. It was under contract law an invitation to treat, so technically it wasn't an offer. So therefore, again, applying the plain, ordinary, literal meaning of the word, he got away with it, which again clearly is an absurd result, because he clearly was, normally offering that for sale. He just wasn't actually offering it for sale under contract law. So all four of those cases, they are applying the plain, ordinary, or literal meaning of the word, even though all of them produce absurd results. If we look at the golden rule, which is another rule a judge could apply, and remember these rules are rules of interpretation, it's up to the judge as to which one to apply. Certainly the fourth one, the purposive approach, is the most modern one, so that's the one we'll look at last. These are slightly older ones that judges don't tend to look at anymore, but could. Now, the golden rule is just an extension of the literal rule. So basically, you apply the literal rule first. If you don't like that result, the judge could apply the golden rule. And what it does, it basically, if the literal rule produces an absurd result and the judge thinks, well, no, I don't like that, then what they can do is they can interpret a word or the words differently to produce a more appropriate interpretation. So it's clearly an extension. If the literal rule produces an absurd result, you can change it. And that's what the golden rule is. Now, there's two ways the judge can change it. The first is the narrow approach, which is a long sentence there, which is if a word has two or more possible meanings, the court can choose the most appropriate meaning between the options, but can't do anything more than that. So it's narrow. The wide approach being if the word has only one possible meaning, but this produces an absurd result, the court can just choose a new, completely different, more appropriate meaning. So summarising those more clearly, the narrow approach is where you slightly change the wording, or you slightly change something that's within the meaning of those words. You're not making a significant change. Whereas the wide approach is you're just completely changing the law. It's clearly what it says, but that produces an absurd result. So you're just going to change it to a different thing completely. Hence the wide versus the narrow. Now, in R v Allen, this is quite a complicated case. It was a case of bigamy. He was charged with bigamy, which is where you marry more than one person. And the law was the law actually wording was shall marry any other person. Now, technically, the problem with this was in this case, and it was argued in this case successfully, if you applied the literal rule, well, you can't. If you're already married and you marry someone else, you can get married, you can have a wedding, you can call them your husband and wife, you can sign the book, etc. But that second marriage is automatically void because you're already married. So therefore, the lawyer successfully argued in this case and said, well, it says shall marry any other person. You can't marry another person if you're already married. So therefore, technically, the law of bigamy was impossible to be convicted of because you can't get married twice legally. You can try, you can go through a marriage ceremony, etc., and call them your husband and wife, but they're not legally your husband and wife because you can only be married once. So therefore, the judge applied the golden rule and said, well, that's nonsense. Let's just say shall marry any other person means shall go through a marriage ceremony. So basically, if you're married and you go through a marriage ceremony, then you can be convicted of bigamy, even though technically that second person isn't legally your husband and wife. You've gone through the marriage ceremony, so you're committing bigamy. So they just made that slight change. So that was a narrow approach change. They just slightly changed the wording. So shall marry, shall go through a marriage ceremony. It's a similar thing. In R.E. Sigsworth, a person, the defendant murdered someone, and they were due to inherit, and the person that's due to inherit is called the issue. And the issue in this case was the judges said, well, how can we allow someone that's murdered someone to inherit from them? That clearly can't be the law. But the law was very clear. There was no other definition. That there was no other way of getting around it. It didn't say you couldn't. So the judge used the wide approach in this case and said, well, that's an absurd result. We can't let this. So they just changed the law and said, no, you can't. If you've murdered someone, you can't inherit from them. So that's a clear example of the wide approach. They just completely changed the law. Adler v. George. So this was where the defendant was found in an army or naval base, a sort of armed forces base, and they were charged with obstructing the Majesty's services in the vicinity of this army or navy base, etc. The defendant argued in this case, well, I wasn't in the vicinity, I was actually in the naval or army base. And applying the literal rule, technically that's true, so technically they shouldn't have been found guilty. So the judge applied the golden rule and went, well, clearly in the vicinity could also include in, not just the surrounding area. So again, that's a narrow approach case because it's just a slight variation of what in the vicinity means. So that's the golden rule. Looking at the mischief rule, this is where the court considers the mischief that Parliament was trying to stop when they first passed the law. And then what they do is they interpret the word or words to best give effect to stopping that mischief. So it's all about like why. Why did Parliament pass this law in the first place? What were they trying to do? What mischief were they trying to stop? And then let's interpret it to achieve that purpose, essentially, to stop that mischief. The main case on this is a really old case called Hayden's case, and it established sort of the test for applying the mischief rule, which was these 4 statements. What was the law before making the act? What was the mischief they were trying to stop? What was the remedy that they chose to try and stop that mischief? And why? What was the true reason for that remedy? Why did they choose that remedy to stop the mischief? And those 4 questions, if you answer those, essentially give you your answer, apparently, to applying the mischief rule. The 3 cases on this, first case is Smith v Hughes, which was to do with prostitution, and it essentially banned prostitution in a street or public place. In this particular case, the prostitutes were actually behind windows or on balconies, so they technically weren't on the street or public place. So again, applying the literal rule, they would have been found not guilty. But actually they looked at what was the purpose of the legislation, the Act of Parliament. The Act of Parliament, the purpose was to stop prostitution. So they said, well, let's apply it to stop the mischief, and let's say that this is still a mischief. So let's say that they're still breaking the law clearly. So they were found guilty. In the Royal College of Nursing v DHSS, this was to do with abortions, and nurses were carrying out abortions, and the Royal College of Nursing basically said, well, let's find out whether this is actually legal, and then if not, we'll tell our nurses to stop doing it. When the law was written under the Abortion Act, it said that only registered medical practitioners could carry out abortions, which essentially meant that only doctors could do it. Unfortunately, well, not unfortunately, but by the time that this case came about, the abortions were fairly simple procedures, so at least some abortions, so nurses were carrying them out. So the question was, applying the literal rule, clearly they shouldn't be, because it would say only doctors can, but clearly they looked at the law. In this case, they looked at what was the mischief that the Abortion Act was trying to stop, and it was backstreet, unhygienic abortions, and nurses weren't doing that. It was safe, it was hygienic, so therefore it was perfectly fine to carry on doing it. Finally, in Corkery v Carpenter, the defendant was caught riding a bicycle whilst drunk and dangerously. The only law they could find to convict him of was using drunken charge of a carriage, essentially. And again, they looked at what was the purpose. Literally speaking, a bicycle clearly isn't a carriage, but applying the mischief they were trying to stop with the law was to stop dangerous use of vehicles, essentially, whilst drunk. So again, that applied in this circumstances, and they convicted. Finally, the purposive approach. This rule goes beyond the mischief rule in the fact that the court's trying to determine what actually was Parliament trying to achieve, really focusing on the purpose of the Act. Because the mischief rule was obviously not all acts are brought about to try and stop a mischief, so but they all have a purpose. So the purposive approach is much wider. It's extensively used by EU countries, and of course was used by the Court of Justice of the European Union, which meant that we used it for many years. Obviously, since Brexit, the Court of Justice of the European Union is no longer the top court, but certainly what we would expect, English and Welsh courts, they're probably going to carry on using it to some extent, if not fully. The main cases on this are Jones v Tower Boot Company. In this case was to do with the Race Relations Act, which made discrimination obviously sort of an offence and actually something that employers had to deal with, and they were in charge of dealing with it in the course of employment. In this particular case, the employer was being discriminated outside of work by employees, and the employer didn't do anything about it. And the court said, well, hang on, the purpose of the Race Relations Act is to stop discrimination, full stop, racism, full stop. So therefore, the employer should have done something in this instance. It was within their remit to do that. So they're applying the purpose of the act there. So, in this case, RV Registrar General ex parte Smith, this was to do with the Adoption Act. In this case, a murderer was in prison and he killed 2 people, and he found out that he had been adopted, and the therapists in prison basically were worried because he was basically saying things like he blamed his birth mother for the situation he was in and his life and things like that, and they were very concerned that if he was to find out actually who his birth parents were, that they would be at serious physical risk if he was to be let out or escape or those sort of things. Now, the Adoption Act was very clear, from a literal rule approach to interpreting it, that anyone over the age of 18 is entitled to find out who their birth parents are. So there was a very difficult situation here, and the court basically said, the purpose of any law can never be to allow harm to happen. Parliament, when passing law, would never ever want harm to be caused. So clearly, in this circumstance, had they thought about this, they would have said, well, clearly this person shouldn't be allowed to find out. So it was a bit of a stretch, clearly, but clearly probably the right decision in that case. So the court said, no, you can't find out, really sorry, no, you can't have it. Finally, in the case of R. Quinterval v Secretary of State for Health, this is to do with cloned embryos, actually, and the law very clearly said that any embryos where fertilization is complete, which is the natural process of the sperm and the egg, can only be tested on for a certain amount of days before they have to be destroyed. The question in this case was, well, did cloned embryos where fertilization hadn't taken place because they were cloned, so therefore the fertilization originally happened with the original cells but not the cloned ones, could they be tested on for longer? Did they apply under the Human Fertilization Embryology Act or not? And again, the court said, well, look at literally speaking, no, but let's look at the purpose of the act. The purpose of the act is to cover testing on all embryos regardless of how they've come about. So therefore they said that clearly it would be the regulations, the law would still apply to cloned embryos, and they'd have to be destroyed after a certain amount of days, etc. They're the rules of interpretation. You also need to be aware of the rules of language, and you need to be really careful when answering the question that you're choosing the right answer. So you need to be clear on what they're actually asking in the exam. Now, the rules of language are in Latin. You don't need to know the Latin translations. You can use the English translations. That's absolutely fine. And there's a case for each one. So if we work through these, and forgive me because I can't speak Latin and I don't know how to pronounce these correctly, so I'll just pronounce them as I do. But apologies if it's completely wrong. The first one, expressio unius exclusio alterius, that translates roughly to the express mention of one thing excludes others. So what it essentially means is if you have a law and it says the law applies to apples and oranges full stop, then the law only applies to apples and oranges. If you asked, well, do bananas apply under this law as well, you'd say, well, no, because it expressly mentions apples and oranges, and that's it. So you can't include anything else. This can be seen in the case of Tempest v Kilner, where a contract for the sale of goods, wares and merchandise of more than £10 had to be evidenced in writing. That was what the law said. The question was, did it apply to stocks and shares? And they looked at the case, they looked at the wording, and they said, well, it says goods, wares and merchandise. That's it. It doesn't say anything else. It doesn't say another types of agreements. It just says goods, wares and merchandise, full stop, have to be evidenced in writing of more than £10. So therefore, the sale of stocks and shares did not come under this law according to the court, because the express mention of one thing excludes others. The second rule of language you need to be aware of is adjustum generis, which roughly translates to of the same kind. Now this is where you have some specific words. So you might again have apples and oranges and other food. So when you had that phrase other food, that in terms of deciding what comes under that other food, it's of the same kind as the specific word. So clearly in that description I've just given, apples and oranges and other food, the other food would clearly mean fruit. So the question is, well, would steak come under it? You'd probably say no, because it's not the same kind as the specific words in the list. If it said, so it says apples and oranges, which clearly means fruit. In this case, Powell v Kempton Park Racecourse, the law was keeping a house, office, room or other place for betting. And the question was, well, did an outdoor betting ring break this law then? If you look at the words in the law, keeping a house, office, room or other place for betting, they're all the kinds of things they all are, inside things, in a building. So therefore, the judge in this case said, well, no, an outdoor betting ring isn't of the same kind as those things then. So it fell outside of this remit of this law and this definition, therefore wasn't breaking the law. Finally, necessitira socis, the rough translation of that is a word is known by the company it keeps. This is often known as the context rule. The main case on this is a case called Pengelly v Bell Punch, which unfortunately, isn't on that slide there. There's a case called Pengelly v Bell Punch. And in that case, the law was to do with keeping floors, steps, stairs, passageways and gangways clear of things. So there were no trip hazards and things like that. And they had to be free from obstruction, essentially. And in this particular case, the person was being prosecuted or be found liable because they were using an area of a floor for storage. So the question was, does the area of floor of this corner of the room, does this count? And actually, looking at the context, the word known by the company it keeps, these other words, floors, steps, stairs, passageways and gangways, they're all to do with sort of corridors, keeping corridors free, and therefore the corner of a room clearly wouldn't become under that definition, so therefore the person wasn't liable or prosecuted. The other thing you need to know is the aids to interpretation. So what do judges use to help them with statutory interpretation, to interpret law, interpret statutes? There's two different categories here, intrinsic and extrinsic aids. Intrinsic aids are anything within the act itself. So internal, external is the best way to think of these. Intrinsic, internal, extrinsic, external, anything outside the act itself. If we start with intrinsic aids, you could look at the long and short titles. All laws have a short title, which most people know the statute by, but they also have a longer title which gives more of a definition as to what the law's for, perhaps, or things like that, or what it's really about. That might be helpful in the judge interpreting the law. The preamble, which lots of older statutes have, the preamble was a very useful bit at the beginning of all statutes, which gave you a lot of context, why the law was being passed. So that one was particularly relevant to the mischief rule and the purposive approach, in where judges needed to know a bit more about why the law was being passed. But that no longer exists on newer statutes. There are no preambles. Newer statutes do, however, have explanatory notes, which are notes that go throughout the statute, usually in the margins, but can be in more detail, explaining the context as you go through the statute. So it's largely a preamble, but taken out through the entire statute rather than just at the beginning. And that can be very helpful, particularly for, again, the purposive and mischief rule. Some statutes have interpretation sections which tell you what they mean by certain words or certain bits. A classic example is the Theft Act, section 4.1, which defines property, and it tells us that it includes money and other things. Another good definition under the Theft Act is it is a little bit of a definition of what's included within the definition of the word building, which includes sort of caravans and things like that. So there's a bit of a wider interpretation. So they can be really helpful for judges in deciding what comes under the law. Some sections have titles in statutes which can be really useful. A good example of that is in Shah and Shah, where there was a really clear title of one section where the bit was included, and then in another section it wasn't. It was deliberately not mentioned, so that was found to be quite useful by the judge in that particular case in determining whether the law was included or not under that particular section. Headings and schedules can be quite useful. A good example is the Consumer Rights Act 2015, which has at the end a grey list of potentially unfair terms. Again, that's going to be very useful to a judge. Equally, marginal notes, so notes in the margins of statutes, can give indications of what the purpose or how words are supposed to be interpreted, and they all can be quite helpful. In terms of extrinsic aids, the Dictionary of the Time certainly is going to be very useful. A classic example of that is in the case of Cheeseman v DPP, where they looked at the definition of the word passengers when the law was written. And it usually has to be of the time to indicate what the law was when it was written. Hansard is the written record of the debates in Parliament. Up until 1992, judges were not allowed to look at this. It was absolutely explicitly banned. But in a case of Pepper v. Hart, 1992, they changed the law on this and said that judges can, under certain provisos, there's certain rules to it, they can look at what was debated, and that can be quite helpful for particularly, again, the mischief or purposive approach. But as I said, there are some very specific rules on when you can and can't use Hansard. Judges may look at textbooks, academic journals, law commission reports, other case law, and certainly case law from other countries. A good example of that is R.V. Bentham, when they were looking at an armed robbery case, and they looked at law in America for that particular example, which was quite useful because obviously they've got a lot more law on gun crime than we do. And they use that to help them make a decision in this particular case. Finally, you need to look at the impact of EU and human rights law on statutory interpretation. If we look at EU law first, the purposive approach is used extensively across European countries when interpreting their own legislation, and actually the Court of Justice of the European Union uses this approach when interpreting EU law. Now, of course, the UK became a member of the EU in 1973, so we've been using this law, and this law has been, this sort of approach, the purposive approach, has extensively come into the UK, certainly more than it used to, over the years that we were part of the EU, and English courts started to move towards using it extensively and moving away from the three other rules of interpretation, the literal rule, golden and mischief rule. When interpreting EU law, English courts had to use the purposive approach. That was part of the restrictions with the expectations about interpreting EU law and being part of the EU, and that was obviously prior to Brexit. Even after Brexit now of course there's no requirement for us to do that, but English judges are likely, English and Welsh judges are very likely to continue to use the purposive approach to interpret English legislation. In terms of human rights law, Section 3 of the Human Rights Act 1998 says, as far as it's possible to do so, legislation must be read and given an effect in a way which is compatible with the rights in the European Convention of Human Rights. So what that basically is saying is, when you're interpreting law, you have to make sure it's compatible with the Human Rights Act. Now, that's not per se binding, so you don't actually have to do it per se. You can appeal to the European Court of Human Rights, and that is, the British government can actually ignore those rulings if they want to. It doesn't look great, but they can. But generally they don't. Most human rights law is followed. And don't get confused with this. Remember, we are still part of the human rights law is still applicable, even though we've left the EU. It's nothing to do with the EU, and you just got to be very careful with that. One case that you can look at on here is a case called Mendoza v. Guyden. This was a law to do with the Rent Act, which allowed unmarried partners to continue a tenancy if one of the tenants died. And the Court of Appeal had to interpret the Rent Act in light of the Human Rights Act and held that section did include same-sex partners, and there was a bit of debate as to whether it did. The courts basically said it didn't, and they interpreted it in that way. But the Court of Appeal said, well, no, clearly applying the human rights law here, we can't say that the same-sex partners can't benefit from this, because that would break their human rights. You also need to evaluate the law, which we'll go on to look at now. Okay, so when evaluating the law, you need to look at evaluating each of these rules, the literal rule, golden rule, mischief rule, purposive approach, individually. You could be asked to compare them in theory, but it's likely you could be asked the advantages or disadvantages of each. When answering these questions, I always recommend to my students that they firstly read the question. What's the question asking for? Is it asking for advantages or is it asking for disadvantages? It may use synonyms of those words as well, so it might not use those specific words. So it could say problems, for instance, or other words to say the same thing. You then must make sure that you start with that word they're asking for, that type they're looking for. So if they ask for advantages of the literal rule, you should start each of your paragraphs on these answer with an advantage. You can include disadvantages, but it needs to lead with an advantage and then link to a relevant disadvantage. Only then will it be marked, or only then will it be considered. So it's really important that you don't not answer the question. If it asks for advantages and you start talking about disadvantages, you're not answering the question. If we start with advantages of the literal rule, and then we'll work through. So I'm going to go from left to right with each box. So I'll start with the advantage, then talk about the disadvantage, and then move downwards through the boxes. First advantage of the literal rule is that it respects parliamentary supremacy. Judges are just doing what they're supposed to do. They're applying the law. That Parliament are elected. They're the ones that are accountable. We'll just do what they say. So judges are following the rules. We're following the laws they're supposed to. They're not trying to make the law. It's not judicial lawmaking. So it really respects parliamentary supremacy. The problem is though, by just blindly following the law, it can lead to unjust decisions. You want to give an example here, so you could use any of the cases of any four: Berryman, Cheeseman, Whiteley v Chappell, Fisher v Bell. All four lead to an unjust decision. Berryman's a good example because it was particularly unfair for her. It's particularly unfair, for instance, that Cheeseman was not convicted, because clearly he should have been. So you want to use a good case example there to back up, to show how they can lead to an absurd, unjust decision or result. The next advantage of the literal rule is it makes the law more certain. If you know that all judges were going to apply the literal rule, then in theory, as a lawyer, you should be able to predict the result quite clearly for your client. So that element of predicting the law would be quite relevant to your answer here. And saying that, it makes the law more certain, legal certainty, and the fact that you can predict, it's very clear what the judge is going to say. They're not going to come up with a sudden different meaning and throw the whole case completely for you. In theory, you should be able to predict for your client. The problem with saying that, though, is that words can have multiple meanings. So it's not always as clear cut as that. It's not always going to be that you can definitely say, well, this is what the judge is going to say, because it's not that. Words do have multiple meanings. So it's, in the vicinity, for instance, that's another case, but in a case called Adler v Georgia in the Golden Rule, clearly in the vicinity has different interpretations of what that could mean. But there are a lot, in terms of Berryman, as the difference between relaying, repairing, and maintaining. Could you say that maintaining is included in relaying or repairing? In repairing, possibly, just up to interpretation. The final advantage of the literal rule is it restricts the role of judges, and that's a good thing, because it's separation of powers. Judges are supposed to just apply the law. They're not elected, therefore not accountable, therefore they shouldn't be making law. So, and that respects the separation of powers, which is an important principle from Montesquieu, for instance. So you've got to make sure that you're really clear there, and make sure you use that phrase, separation of powers. But the problem with this rule is that's all well and good, and judges aren't making law, etc. But it assumes perfect draftsmanship. It assumes that the law that was written by Parliament is exactly what Parliament wanted it to be. It assumes there's been no human error, no mistakes, and that interpretation, how they want that law to be interpreted, is going to be the same forever. And actually, words change meaning. So actually, over time, quite quickly, so what Parliament wanted it to be can quickly become something different, even if you're applying the law as you think it should be, as you think it was intended to be, or certainly as it was written, literally in plain ordinary meaning there. Moving on to the Golden Rule, the first advantage is that you can avoid clearly unjust results here, incorrect errors in the law. The key example there being the bigamy case, in terms of clearly the law wasn't possible to break, and that's clearly not what Parliament have wanted. So the judges can fix it. They can say, well, that's not right. We'll just change the law to get what Parliament essentially wanted. But this is essentially judges making a judgment as to what is an unjust result. Why is it an unjust result? It's their judgment. It's their decision that they're deciding that literal rule approach is creating an absurd result. So they are essentially an evidence of judicial lawmaking. They're making up their decision as to why they think there should be a different result. It does respect parliamentary supremacy to some extent, particularly the narrower approach, because their judges argue that they're just picking between words, and they're trying to fix the laws to what Parliament wanted or would have wanted. And again, you can see that in quite a few of the cases, Adler v George as a good example there. But you could just argue it's judicial lawmaking, and certainly in R.E. Sigsworth, where they just decided that this murderer couldn't inherit. There's nothing in the law that said he couldn't. So that wide approach there is clearly, an evidence of judicial lawmaking. It does boost public confidence in the law, though, because it fixes absurd results. In all those first 4 cases for the literal rule, clearly the other people clearly would have been very unhappy with those results, and certainly the police in Cheeseman's cases would have been very unhappy that they didn't result in a conviction, because clearly it should have. Whereas the golden rule fixes those problems and ensures the right decision is made, so therefore boosting public confidence in the law. Unfortunately, though, the last disadvantage is it's very limited, as it's an extension of the literal rule. You can't just go on and just use this whenever you want and just change the law whenever you want. You can only do it if the literal rule produces an absurd result, so you should apply the literal rule first. So it is fairly limited. It's often described as sort of a feeble parachute. There was a academic called Zander that said that, a feeble parachute, so not very useful basically. The mischief rule, the first advantage is that it can avoid unjust or absurd results. So again, you can say, well, literally the literal rule would have produced an absurd result. So Smith v Hughes, technically those prostitutes weren't on the street, so therefore they shouldn't have been convicted under the literal rule. But that's nonsense. That's clearly an absurd result. So the judge just changes it. So that's a good thing. Again, it's public confidence in the law, those sort of things. But it can be difficult to discover the mischief. To get back as to what did Parliament want. I mean, the laws could be written 100 years ago that the judges are trying to apply, so therefore they can't go and ask Parliament, they can't go and ask people what they meant. So you've got to try and discover the mischief, and that can be quite challenging at times to say, why were Parliament passing this law? What were they trying to stop? What were they trying to do? The next advantage of the mischief rule is that it promotes the purpose of the law and Parliament's intention. Clearly, to some extent, it respects parliamentary supremacy and separation of powers then, because judges are still trying to do what Parliament wanted. Okay, they might be putting their spin on it, and they might be putting their interpretation on it, but ultimately it's trying to interpret what Parliament wanted. So therefore it does, to some extent, still respect parliamentary supremacy and separation of powers. But you can just argue that it is just judicial lawmaking in disguise. Judges are deciding what they think the law is. They are just saying yes or no, or yes, this is breaking the law, or it isn't. And arguably it is just judges making their interpretation rather than trying to pretend that it's, they're just pretending that it's that was what Parliament wanted, because we don't actually know. It obviously reforms and improves the law, so it can fix sort of issues with the law, particularly in some of those cases that you can want to again use a couple of case examples here that we've looked at previously to try and back up your point there. But it can sort of fix any issues and improve the law, and again maintain public confidence in the law. Finally, though, the disadvantage is it's very old, and it can produce uncertainty because it's not always clear, as we've said, what the mischief is, and it can be difficult for lawyers to advise in this one because you can look at multiple sources to try and find out what the mischief was, and it can be quite difficult to advise your client. Finally, in the purposive approach, again, it avoids absurdities. It stops stupid results that you would have got with the literal rule, because you can actually apply just what is the purpose. But again, just as similar to the mischief rule, it can be really difficult to discover what the true intentions of Parliament were. It's not always very clear to find the purpose, certainly if the law's quite old, so therefore is it not just judges making the law. It can be useful for new technology. A good example there is the Quinterval case of the cloning. Clearly the judges, when they write the law, they can't anticipate all future changes in technology, so it's really important that any future changes are brought in line with the purpose of the law, and that Quinterval case is a really good example to use there. But again, it can lead to uncertainty. It's not clear how judges will apply the purposive approach. You don't necessarily know which way they'll go with it. So again, it can be difficult to advise your client as a lawyer. It does give greater judicial discretion. So judges can fix absurd results, as we said, and they can apply the law and a better result, one might argue. But again, that is clearly just judicial lawmaking. Judges just deciding what they think the law should be, and that goes against parliamentary supremacy and separation of powers, which you want to make sure you mention there. There's a real issue with that, with the purposive approach, and certainly you could talk about the EU law adopting it and how we've adopted it there as well. Finally, you might want to consider the advantage and disadvantage of the different aids to interpretation. The good thing about intrinsic aids is they can be found in the statute itself, so they're very easy to look at. And of course, Parliament wrote that. Parliament wrote that statute, so therefore, it's using the intrinsic aids really respects parliamentary supremacy and separation of powers, because it's what Parliament wrote, it's what they said. So therefore, using those is very clearly fair. However, not all intrinsic aids are found in every statute. So you don't have the preamble anymore, for instance. The marginal notes aren't always particularly clear if there are any. You might not have any interpretation sections. The headings might not be particularly clear. Statutes are written very differently. There's no set format, so therefore you might not find anything in Act that's particularly helpful. Second advantage is Hansard is available to everyone and provides the entire parliamentary debate, so it can be really, really helpful. As we said, since Pepper v. Hart 1992, judges can now use this with the proviso that there is some specific rules as to when you can use it. But it can be really helpful, particularly for the mischief and purposive approach and trying to find out what that mischief or purpose was. However, it's not always that useful. The word you're particularly looking at, trying to get what interpretation was, may not have even been mentioned in the debate. And actually going through those records and trying to find that can cost clients a lot of money. And as we said, there's very strict rules on its use anyway, so you can't just use it. You have to meet the rules to use it anyway. The final advantage is that law reform body reports can be very helpful. The law reform, particularly Law Commission, extensively look at the law and look at the ways in which it's used, interpreted, and different versions of that and different ways of doing that. So law reform body reports can be actually really helpful for judges in interpreting particular sections as to what Parliament wanted, etc., particularly for the mischief and purposive approach. But the reports, again, there's no set format necessarily. They are not always that useful, and again can waste clients a lot of money if lawyers use them to try and find certain and spend the time looking at them to try and find certain interpretations. Thank you very much and hope you found that useful. Please don't forget to like, comment and subscribe, and join us again soon. Thank you very much.